Okay, lovely. Thank you. Um, so thank you ever so much for the opportunity to come and talk to you today. Um, so as Jim said in the introduction, I'm the president of National Union of Journalists. And yeah, we're a trade union. We're the voice for journalism and journalists in the UK and Ireland. All of our members sign up to a code of conduct, and within our democratic structures, we have an ethics council, equalities council, and our policy committee, which all seek to promote and protect the ability of journalists to uphold the code and to produce ethical journalism. And that goes alongside all of our core day-to-day work. Within our code is this clause on media freedom. And it says that a journalist at all times upholds and defends the principle of media freedom, the right of freedom of expression, and the right of the public to be informed. And this principle is absolutely core to all of the lobbying and the campaigning work that we do as a union. Our members work in an increasingly hostile environment. We've seen multiple efforts to restrict our ability to report freely and safely. Today, we've been discussing global concerns around media freedom and safety of journalists. But it's very much a cause for concern here in the UK too, even if it does look a little bit different in terms of how it presents itself globally. So here in the UK, we've seen an increase in restrictive legislation, online and physical attacks of journalists at work. Jing identified a few of these issues in her presentation a short while ago. So, you know, the actual safety of journalists, legislation like the National Security Act, the Public Order Act, and I'll be focusing on the dangers of SLAPs, which are strategic lawsuits against public participation, also known by some as lawfare. So SLAPs are lawsuits that are brought by the powerful and rich against journalists to influence and stymie reporting, wielded by the wealthy. They result in lengthy court cases with huge financial burdens on those seeking to report in the public interest. William earlier today referenced Thomson Reuters research, which showed how the use of SLAPs has risen globally. But the true scale of SLAPs is actually quite difficult to measure. And it's a cause for concern for all of us who believe in a free press with the ability to uphold our democratic society. So publishers have received threatening emails and letters warning them off publication. And the NUJ is very clear that this creates a chilling effect within our industry. The NUJ is a member of the UK Anti-SLAP Coalition, which is actively campaigning for an end to the use of SLAPs and for stronger legislation to ensure protections for those that are targeted in efforts to shut down public participation. The use of SLAPs is a deliberate attempt to stop public interest journalism, influence editorial outcomes. It creates a chilling effect that goes beyond those individual cases. So whilst the abuse of legislation by those in powerful positions isn't new, the union's concerned about the increasing use of SLAPs to deter and stymie journalists in their reporting. And there are a number of well-known cases where this approach has been used, including Roman Abramovich's against Catherine Belton for her publication of her book, Putin's People. Also, Eurasian Natural Resources Corporation against Tom Burgess and the Financial Times over kleptopia. And the union condemns both of these actions. And these cases have raised awareness about the impact these lawsuits have on freedom of expression and public interest journalism. And it's important to recognise, however, that SLAP cases don't always reach court. They don't often receive media attention. And that's why it's quite difficult for us to precisely say just how much of an impact it has and how many journalists have been affected. The NUJ believes that the high-profile SLAPS cases that are in the public domain are just the tip of the iceberg, and it doesn't reflect the volume of threatening letters and interference that takes place pre-publication of stories. So our members have told us of the significant financial and emotional distress that's caused by receiving legal threats, including in the form of emails and letters. And journalists ensuring that they offer a right of reply, which is an important step ahead of publication, are then finding themselves faced with threatening correspondence that fails to answer the questions that they pose, and that correspondence is designed to deter and stymie publication. Law firms often send these letters on behalf of their clients in a manner that's designed to make the publisher and the individual journalist back off. And the abusive process is often very drawn out and often goes unreported. So we really don't know the true scale of SLAPS, because many of these letters have led to journalists rethinking publication. We've recently asked our members of the NUJ, if they've experienced this kind of behaviour, what sort of examples that they can give. And so we hope that this will start to bring us further examples that we can use as evidence in our lobbying. But we also recognise the growing trend of journalists directly receiving threats of legal action. So previously, threats and lawsuits were targeted at publishers who were considered responsible for the publication of content. But the impact of this shift towards targeting individuals in the use of SLAPS is to ensure a chilling effect and no doubt instill fear that deters any future journalistic content on a particular issue. So for small publishers and freelance journalists without the backing of a large legal team or without financial resources or support structures, avoiding publication is often the most appropriate course of action to prevent bankruptcy. And where publication does proceed, reports can often be watered down in fear of legal action. And this means that stories, including those about financial misuse and corruption, these stories that are really in the public interest, are increasingly going untold. The NUJ is aware of examples including, large news publisher receiving letters from lawyers informing them of legal action being taken against an individual journalist. So whilst not directly threatening action to the publisher themselves, the letters were worded in a way that served as a warning not to consider publication on the topic in question or face legal action too. And this behaviour at the pre-action stage serves to intimidate and prevent reporting on public interest matters. The opportunity costs of trying to defend oneself against the SLAPS case can be considerable. And, the whole process redirects time and resources away from stories and reporting that would otherwise have been pursued. Freelancers then have that additional burden of legal action inhibiting their ability to carry out other paid work. The NUJ has long called for freestanding anti-SLAPS legislation. And in terms of legislative reforms, we believe that any statutory definition of SLAPS must be broad and needs to consider the tactics deployed in their use alongside the characteristics that feature across cases. So this includes threats against individuals instead of those they work for, a review of previous history of legal intimidation, especially using the same law firms, and issuance of legal threats at right to reply stage and lengthy and complex communication prior to publication. So our concern is that a rigid definition of SLAPS could mean that cases fall outside of scope, which increases threats to journalism as loopholes are found in any potential legislation. But not all SLAPS cases are brought forward using defamation law, and that's why we believe that any amendment to a new right of public participation should be a freestanding measure. So not just merely amending defamation law, it needs to be wider than that. Cases against journalists and publishers are also taken based on data protection and privacy laws. The recent Bloomberg versus ZXC judgment by the UK Supreme Court means that claimants can now seek damages for misuse of private information. So the use of this defence instead of the serious harm defence in current defamation law is a huge concern to the NUJ. We fear that journalists may continue to see an increase in the use of privacy arguments in SLAPP cases at pre-publication and pre-action stages.
Sorry, Natasha, 5 minutes left. Thank you.
Okay, thank you. A defamation defense fund has been created by the US Agency for International Development, which is aiming to protect investigative journalists against nuisance lawsuits designed to prevent them from doing vital work. And we call for the creation of a similar fund here in the UK. And in terms of reform in the UK, we also argue that there should be an opportunity to strike out a SLAPP's application at an early stage in the litigation process. Once a lawsuit has been determined as a SLAPP, the judge should have the power to prevent any further abuse of legislation. And we've long campaigned for low-cost arbitration solutions to settle genuine disputes, and we would welcome any moves to ensure that journalists and media outlets no longer face prohibitive costs and deliberate intimidation by wealthy litigants with the deepest of pockets. For too long, the super rich have got away with abusing the law to bully journalists and undermine media freedom. The high legal bills that are involved in bringing the SLAPP's case do not act as a deterrent to wealthy individuals, but instead they do tie journalists up in knots because cases can proceed for years, and it's a tactic that we see being used. So reducing costs throughout the process, putting a cost cap on damages that claimants could seek would be positive in reform. And we're also dismayed at the Court of Appeal's decision in May, where they instructed Carol Cadwalladr to pay in excess of £1 million to Aaron Banks for her 2019 TEDx talk. And again, it was directed at her as an individual and not at the platform that published that talk. SLAPP's cases in the UK have also been linked to financial crime. So previous investigations into how cases have been financed found links to corruption and dirty money. So used to prevent publication of stories, these cases negatively impact media freedom. And SLAPP's type litigation clearly presents an abusive process because it's used with the intention of causing financial and emotional harm to defendants. And public interest journalism is a vital service, and adequate reform will ensure better protection for journalists and others who seek to report on such matters. Other speakers today have highlighted the gendered nature of attacks directed at journalists, and this has the additional consequence of reducing plurality and diversity of voices in journalism. So it's absolutely necessary that urgent action is taken to ensure that free speech remains free. In 2021, the UK Anti-SLAPP Coalition developed proposals for reform to counter that legal intimidation, and it includes a model law that has 3 important features for handling SLAPP cases. So a higher merits threshold, wide and robust criteria for identifying abuse, and an objective test for dismissal. And you can find out more about this online if you're interested in that. But there is progress in the UK. So on the 6th of December, Wayne David, who's the MP for Caerphilly, which is just up the road from me in Wales, presented the Strategic Litigation Against Public Participation Bill. It's a private member's bill, and it was presented to the Houses of Parliament on the 6th of December. So the NUJ has welcomed the bill, will be monitoring it closely, and it represents a move towards that standalone legislation towards SLAPPs that we've been calling for. And my last slide here, the NUJ sits on the National Committee for the Safety of Journalists, and a UK government-led SLAPPs task force was established in September, which comes under the remit of the Safety Committee. And through our seat on the task force, we're raising these concerns about the impact of SLAPPs on journalists. The updated National Action Plan from the Committee for the Safety of Journalists commits to exploring the launch of an online tool to enable data gathering on safety issues taking place in the UK. So this will essentially be a safety tracker, and journalists will also be able to report if they've received legal threats, including slaps, and to access relevant resources. So right now it's very much watch this space in the UK as the private members bill starts to make its progress through Parliament. But we're hopeful that we're starting to see some progress in the right direction here. So thank you very much.